the defendant naked while sitting on a patio bench while masturbating. When officers arrived on scene, the defendant continued masturbating while in the officer's presence.
Judge David Fleischer sees a range of cases in his Harris County courtroom. Today, two defendants who couldn't be more different. Welcome back to In Session. First, a man charged with indecent exposure, sitting naked on a patio bench, and he didn't stop even when officers arrived. The judge orders a drug test immediately. Then, a repeat offender who stood before this judge before. Let's start with Mr. Perez Gonzalez.
Good morning, Mr. Perez Gonzalez. Mr. Perez Gonzalez, you're charged with an indecent exposure with a previous conviction. You're facing up to a year in jail and or a $4,000 fine. You're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
Officers were dispatched to an apartment complex in Harris County, Texas. The complaining witness stated that he observed the defendant naked in the apartment pool and asked him to leave. The complaining witness stated he later observed the defendant naked while sitting on a patio bench while masturbating. When officers arrived on scene, the defendant continued masturbating while in the officer's presence.
I'm going to find that there's probable cause to go forward with the case, Mr. Perez Gonzalez. If I test you for drugs and alcohol, what are you going to test positive for? I'm sending you now for a drug and alcohol test. I want to know what, if anything, you're going to test positive for. You're to come right back. If you fail to come back, I'm going to revoke your bond, and I'm going to make it high. Do you understand? Hey, Vic?
Yes.
I'm sending him for a drug test.
Okay.
And then when he comes back, we'll appoint him someone. But you are to come right back after your drug test. Do you understand? Okay. Head on over that way.
Right this way.
We still need to do a whole host of conditions after the fact, but we'll do it after the drug test. This is his 1, 2, 3, 4.
Did you catch that? Indecent exposure. And the defendant kept going even with officers right there. Judge Fleischer's first move was a drug test, because behavior like that doesn't happen without something in your system. Should indecent exposure cases always require mandatory drug and alcohol testing? Comment test or no test. Let's see what you think. Now, our next defendant has seen this judge before.
Oh, Kennedy, that's right.
Yeah. We learned, I was talking with the clerk that it was set as like a 2B.
But, you know, I got it as a 2B.
But it doesn't show up on the clerk's website at all from a public perspective. So like the only reason we knew it existed is because we came in off docket the original case. And like I still can't pull it up now unless I go through the portal.
Is that something that they normally can see? I don't think that you can see 2Bs.
So like felony 2Bs I can usually see. Misdemeanors, I guess we just don't get them too often. Where,
That's weird.
Yeah.
I don't know. Can you see 2Bs on the
Well, we have more access than they do. So
if I were to just like go look on anyone in the public, can they see the 2 weeks for misdemeanors?
Yeah, it's so
I don't know.
I can't see any of the filings in the case or anything like that, which is just, I don't know. It's interesting.
Well, I'm glad that you find out.
Yeah.
I would have reached out to you regardless to let you know about the bond violation. So,
So I know with Mr. Kennedy today, he said on the assault case, there's obviously this DPO that exists. I have spoken with the state. My intention, of course, is to ask that I am able to walk him through on the VPO. I know the state will read off their summary, of course, but summarization from our perspective is this case happened. We walked him through on Friday. You said no contact.
you did a walkthrough the first time, right?
Correct. That was on Friday. It had been out for like 2 months and we didn't know about it. With the whole 2B thing, I was able to see that one, but not this one, So they've been separated for a while. They live at 2 different houses and have lived at 2 different houses. After this, his wife wanted to tow a car that was at his house, which is under both of their names. So she reached out to the constables. The constables drove over with her in order to try and get this done. The constable met Mr. Kennedy. He didn't want to speak to the police. Obviously, having a case going on, I get it. And so told them that they needed to leave. They checked back with her. They said, "Have you guys spoke?" And they're like, "Well, he called me the other day." Which was Saturday, and the cop looked at the call log, and that was it. 2B gets issued. To my knowledge, based off of what I've read on the...
Did we do no contact or did we do no threatening or harassing? I don't remember.
So Manny was here for that one. I want to say it was no contact.
It's no contact, Judge.
It was whenever I had initially spoken to him before he had come, I was under the impression it would be a MOA based off of kind of how we felt everything was going to go out. But I think it went to a full no contact in court. But from what
I always ask, what the complaining witness wants. And I always want to honor what their wishes are. So if they don't want to have contact, then I'm going to give them no contact.
Yeah, and we've certainly gotten conflicting messages from how we thought it would play, let's just say.
Looking from him?
No, from the complaining witness about her wanting to proceed.
So you've been in contact with her?
So when we made contact, we go like, nope, don't want anything to do with it. Then we came into court and it was...
Just telling them something different.
Right. So when the officer looked at the call log, all I know is that he looked at a call log. And that's it. Doesn't necessarily mean that they looked at the number.
I remember reading something that he's in the middle of the street.
Yes, Judge. Yeah, an officer gets a report that he towed the complaining witness's vehicle. He goes to his address to search for the vehicle. He doesn't see the vehicle.
One second. A vehicle gets towed from whose house?
The complaining witness was staying with her sister. She calls officers and says that he owns a tow truck business and thinks that he towed her car. So the officer goes to his house to see if the towed car is there. He drives past once. He's standing out in the yard. He drives back.
And we're talking about he's in his house now.
Yes, he's at his house. The officer drives past his house. He's in front of his own house in the yard. Officer comes back down the street and he's standing in the front of the road and starts yelling at the officer.
And at least from our perspective, he owns a body shop, not a company. And the officer had come down the street and had said, "Oh, Mr. Kennedy," and he came out to the street set. And that's when essentially there's yelling.
So the only reason for PC is the alleged phone log.
Yes, Judge.
How do you know he did it?
The complaining witness showed the officer the call log, which showed...
Right, but it's a call log, right? Did she actually speak to him? Did she say she spoke to him? How do we know it wasn't his brother that made the phone call?
And also to add to that, Your Honor, I can always change my wife's phone number to say Domino's
Right.
Pizza.
There's so many phones that can spoof, there's so many vindictive people in this world. It's unreal. So, if she tells the officer, yeah, he called me, I spoke to him, and it was in violation of the no contact order, then yeah, there's probable cause. But if we have just a phone call and we don't know, just a log and nothing else,
Allow me to read directly from the Dems, Your Honor.
Sure, of course.
The complainant advised that the defendant had called her at approximately 1:30 hours to ask her to call the district attorney's office to drop the assault charges. He also called to tell her that he did not
Okay,
do
that's
anything
what,
for her.
okay, now that's clicking in. So he calls her saying, hey, man, drop these charges.
Yes, Judge.
What was the date of that?
The date was,
Entered all the conditions on 10-4, by the way.
I don't see another date alleged besides the October 5th date, Judge. So
This is the phone call with the law, right?
yes, Judge. And then she showed the officer the log as corroborating evidence.
See,
Your Honor, strictly if I have an individual who is certainly mad that she wants access to a vehicle so much that she's had a constable come out, I wouldn't put that past somebody who could change somebody's name in their phone to make it look like they called.
if we had just a phone call log,
Right.
I was going to find no PC. But if she is saying in the sworn statement that he made a phone call to her the day after he had court, telling her to drop the charges, that's a violation. And remember, this is only probable cause. So by
Yes, Your
no
Honor.
means does it mean it's beyond a reasonable doubt.
And I understand with that. And at least in the alternative, I'd ask that, a bond be set so that I can
Yeah,
have a bondsman
someone
come
to set
up
him a
here.
bond, but I'm not giving him 2 walkthroughs. I gave him a free walkthrough once. The day after he allegedly makes a phone call trying to obstruct, no, I'm not, it's not going to happen again. And I'm going to tell you now, I'm putting conditions on this bond now. And I'm going to tell you now, the Texas Constitution does not allow me but in extremely limited circumstances to have a hearing to hold someone at no bond. 0 bond. This is one of those occasions where I'm going to put conditions on your violation of protective order. You violate conditions, I can have a hearing to hold you at no bond. And I will do it in a heartbeat to protect every person of this county. Do you understand, Mr. Kennedy? I don't care what your excuse is. I don't care if Mother Teresa tells you to make a phone call. You violate conditions. We will have a very, very disturbing hearing. Now, I will not put an ankle monitor on at this point because all we have is a phone call, right? If we had something more overt, like he's going over there or doing something like that, then I would take further action like ankle monitors, curfews and the like. I'm not going to do that at this point, Mr. Kennedy, but I'm going to tell you, any more issues, it's going to go really sideways real quick. Do you understand? Okay. Bond recommendation.
I believe a $10,000 surety bond, Your Honor, will be sufficient based on the fact that a single day after he received conditions to not contact the complaining witness in an assault family member case, he did so in an attempt to get her to drop charges and obstruct justice.
Your Honor, I believe that used to be the bail schedule for a second-degree felony. I would ask that bond be set at 1,000, given the nature that this is simply a phone call. Mr. Kennedy and I will, of course, be in very tight communication about him staying in line with his bond conditions. I will personally make sure that I check in with him weekly to make sure that he is not making contact. But I think setting an oppressive bond in an instance like this would be inappropriate, as he's still accused.
Split the puppy. I'd do it at 5.
Thank you, Judge.
So, but you got to understand, I am now also going to revoke your bond on the assault case, and I'm also going to make that 5,000 as well. So now both will be at 5,001. You now know what's expected of you. We don't mean business. I'm going to take you into custody now so that you know that we mean business. And the next time you do anything, we will have a hearing to hold you at no bond. Do you understand, Mr. Kennedy? So hopefully this is enough of a wake-up call for you to realize that we mean business. So do you mind filing conditions on the VPO so that way if he files,
Yes, Judge.
say no contact, no weapons, anything else?
No contact, no weapons. I believe the Moab, would you like them to mirror the Moab so there's also the residency restriction? I know that complaining witness is currently staying with her sister.
Does she want the residency restriction?
I'll ask her before I put it on.
Ask. And if she does, then I will, because I'm going to do what she wants. But if she's okay with not, then
Can we get a sister's residence you'd be asking for?
Yeah.
okay, guys. So we're going to take him in now. Well, I'm going to set the bond now. So I'm sure you have a bonding company now.
Yeah.
I'm sure you'll make it within the next 5 to 8 hours anyway. So it's not like he's going to be there forever. But just please impress on him that next time it's okay.
Okay. Thank you, Judge.
Don't send him down there, please. Guys, thanks.
Thank you. Oh, maybe we gotta go out to excuse.
Oh, yeah. You know what? I'm going to do a new mower on
Okay.
PO.
Two cases, one judge, an indecent exposure that raises questions about the defendant's state of mind, a repeat offender getting one more chance. Judge Fleischer doesn't just punish, he tries to understand and warn. Which case worries you more, indecent exposure or the repeat offender? Comment exposure or repeat. Let's see what you think. Thanks for watching In Session. Check out the other video on your screen right now. We've got plenty more real courtroom moments. See you in the next one.